What you want to know. What you need to know.
Talk 1470. WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the South Florida Family Law Show with attorney Sean Shepard. Sit back today as attorney Shepard shares his vast family law experience. Attorney Shepard has 18 years in the area of family law. He has handled thousands of cases and hundreds of contested trials before both judge and jury. He is here every week to educate you on your rights and to answer your questions pertaining to family law. If you have a question regarding family law, call attorney Sean Shepard toll free at 888-565-1470. And now, here's attorney Sean Shepard.
Good afternoon. Happy Friday to everybody. It's a happy 4th of July as well. Hopefully most of you are off from work today. Some of us aren't today. If you're new to the show, we're here for an hour today. We're here every Friday at 5 o'clock. We talk about anything and everything to do with family law here in South Florida. I'm an attorney. I've practiced in the area of family law for the last 18 years, and I practice locally here in the Tri-County area. I have Broward offices. I practice in Broward County, Palm Beach County, and Miami-Dade County. If you're new to the show, welcome. If you're back again, welcome back. The show is a show that provides information, and it's also a call-in show. If you have any questions, feel free to call in, 888-565-1470. You can also watch the show online at wwnnradio.com. Feel free to call in with questions you might have. If you're going through a family law matter right now, whether it be a divorce proceeding, a paternity action, or any other family law related issues, guardianships, and the like, feel free to call in with your questions. We do cover a number of different topics during the hour. Regardless of what we're talking about, however, we entertain questions from any area having to do with family law, and we encourage you to call in. So feel free to call in and ask questions. If you're going through a divorce proceeding or paternity proceeding, or know somebody who is, give them a call, tell them to tune into the show. We do provide valuable information here to help you through the process of divorce, paternity, and other family law matters. Last week we talked for quite a while about proving up income, and a lot of what happens in divorce court particularly is disputes over how much individuals make, particularly when there's a business involved in a divorce, and we spoke at length about proving up income and how you prove up income, particularly when you have closely held companies, family businesses, cash businesses primarily. It proves very difficult to develop a case to present to a judge to show how much your spouse is making. And we talked last week at length about tactics and trying to prove up income. Building on that, there were a few issues we didn't cover in the hour. And some of those are some formalities in going through a divorce, and these are a lot of afterthoughts and things you may not think of, or your attorney may not think of as you're going through the process. If there is a family-owned business involved in your relationship with your spouse and you're going through a divorce proceeding, it's always advisable from a technical standpoint. And my advice here on the show is provided to those who can't afford an attorney, who are representing themselves, or people involved in a proceeding who have an attorney, and these are more food for thought than anything else. But if there is a business involved in your relationship, whether it be a family-owned business or a business that you're claiming some type of interest in through the divorce proceedings, what you want to do as a pro se litigant, or if you have an attorney involved, is to join that entity in the action you have for divorce. So for instance, if you have ABC Company, a family-owned business, whether it be a landscaping business, any type of professional business that you have, any type of entity that was set up during the marriage that has value to it that you want to claim any equity in for the divorce proceedings, it's very important to name that business in your divorce action, and it's very simple to do that. When you file your paperwork, You file it as Jane Doe wife versus John Doe husband, and ABC Corporation as an additional defendant in the action. It's very simple to add that defendant. You would have to actually serve the business. And what that does is it joins that business in your divorce action, and it gives the court jurisdiction over that business. And the reason that's important is it opens a whole bunch of doors to you to be able to get financial records and other records from that corporation or limited liability company, whatever entity it might be. And it enables the court to enter orders in that case that it otherwise may be prohibited from entering because that entity is not a party to the divorce. So keep that in mind if you do have a business involved that is a marital asset, or it's a business that you're claiming some interest in as an asset in your divorce proceedings, that you want to include that business as an entity in the divorce proceedings. With regard to situations where you have a husband and wife owning 50% of a business together, you still want to name that business as an entity defendant in your divorce action to bring that business under the jurisdiction of the court, to allow the judge to enter orders that affect that business and divide up assets of the business. If you have a situation where your spouse is 100% owner on paper of the business, and you name that business as an entity defendant in your divorce proceedings in order to allow the judge to have access to enter orders relating to that business, you have additional relief that's available to you. You can any number of different remedies you can receive in relation to that business. You can get an appointment of a receiver if things aren't going the way that you want them to go with regard to the business. You can have orders entered against the business requiring the business to disclose financial records to you. It simply opens a whole lot of doors to you that otherwise may not be available if the other party objects to it and says, well, the business isn't a party to this action. I have a case pending right now on that very issue, and it's a post-dissolution matter involving a business as a party, and there's some support issues where one spouse is not paying the support that was obligated to pay, and the support originates from a business, and we're trying to get the court to garnish some bank accounts in the name of the business, and the court refused to do that because the business was not a party to the action. So we've had to go back and join the business as a party to the action in order to allow the judge to attach assets of the business. So it's always best when you start out the divorce proceedings to include the business as a party to your divorce action. Additional matters involving divorce. A lot of people, when they go through divorce proceeding, own real estate together, or they may own real estate. Husband or wife may own the real estate in their own name for whatever reason, whether it was a credit issue or a convenience issue. Whenever you have real estate that was a marital asset that was purchased during the marriage, regardless of how it's titled, you want to make sure that you seek an equitable distribution of that real estate. And we spoke a few weeks about all the assets you can claim to be assets of the marriage. Real estate is an unusual component to any divorce proceeding, and it could be a leveraging issue between parties, and an issue that, depending upon what side of the argument you're on, you can use to leverage the other party. And I'll give you an example. If you have a situation where parties are divorcing, they've been separated, and one spouse has moved out of the house and left the other spouse in the marital home, there may or may not be children involved in the situation. Of course, the spouse that moved out of the home is typically of the position that the real estate should be sold, and they should divide the asset equally by dividing the net proceeds from the sale. And the party who stays in the home typically wants to keep the home because that's where they're living, and a dispute develops between the parties as to what should happen to this property. And one leveraging issue you can take to the court: if you're the spouse who's moved out, and you don't really care what happens to the real estate, you can file what's called a partition action as part of your divorce proceedings. And a partition action is a cause of action in the state of Florida that allows parties who own real estate jointly together, whether they're married or not, to force the sale of a piece of property. And the court has very little discretion to grant that or not grant that relief when it's not a divorce action. So for instance, if you have two people who own property jointly together but they're not married, and one wants to keep the property and one wants to sell it, the one who wants to sell it simply files a partition action with the court, asks the court to partition the property, force the sale of the property just as a foreclosure sale would take place. It's done on the courthouse steps. Now it's internet-based, but it used to be done on the courthouse steps. And the judge orders the sale of the property, and whatever net proceeds are realized from the sale of the property are divided between the owners of the property. It's a very simple cause of action and very limited discretion by the court to do anything other than to force the sale of the property. When you have a divorce proceeding, there is somewhat more discretion of the court to be able to do a few different things with the property. If the parties don't have any minor children together, typically the court will order the property sold and the proceeds divided. If there are minor children involved, and even to some extent if they're not, and you have one spouse living in the property who makes very little income, and another spouse outside of the home who's separated and is the breadwinner for the family and makes all the money, the party in the home who is reliant upon the income of the other party for support and may have children in the home there can seek an order from the court allowing them to stay in the marital home. And the reason you give to do that and to avoid a forced sale of the property is that you want to maintain the structure that the children have in the home. You don't want to force them to move out of the house and be otherwise adversely affected by the divorce proceeding when it's unnecessary to do so. So you want to ask the court, if you want to stay in the property with the children, that the court deny the relief of partition, and that the court allow you the exclusive use, possession, and sometimes even ownership of the property to be able to raise the children in the marital home without upsetting their living arrangements. Because courts are very concerned about the impact of divorce proceedings upon minor children, particularly when children are of an age where they're going to realize such a physical change in their surroundings. And obviously when you have an infant involved who's not going to recognize a change from one house to the other, that differs from a situation where you have a 3, a 4, or 5, all the way up to 12, 13, 14-year-old residing in a marital home. Perhaps it's been the only home they've ever lived in, and the spouse who's residing in the home with the children will ask the court to allow them to continue to reside in the home to maintain that structure and some sense of normalcy to the children's lives. Courts are inclined to grant that relief if it's feasible to do so. Obviously, if financial circumstances dictate that allowing the spouse to reside in the home with the minor children is just completely impossible from a financial perspective, they could still order a partition of the property, forced sale of the property, and then the proceeds, if any, realized from the sale of the real estate could then be used to either purchase another home or to rent a comparable home for the children. But for the most part, courts will make every effort to try and keep the normal structure in place for the minor children who have resided in a home for a long period of time, so as not to adversely impact the children in some way. So you have to keep those things in mind, and depending upon what side of the argument you're on, if from the spouse who's left the home who wants to gain some leverage in the litigation, your argument's going to be that the house should be sold and the proceeds divided. And the other spouse, the leveraging point is going to be that that they want to keep the property and allow them to continue to live there to maintain structure for the children in the home. And those are the two sides of the argument. And those are issues you need to recognize and present to the court. And ultimately, it's up to a judge to decide, depending upon all the factors involved, whether to force the sale of the home or to allow one party to stay in the home. Ultimately, there are issues also regarding real estate that are unique to divorce here in the state of Florida. You may have properties that are marital properties that are not the homestead property where you reside with children or reside primarily. There may be tenants in properties that are owned by the husband and the wife. There may be properties that are out of the state of Florida that you own, investment properties. There may be timeshares, other issues. All these issues need to be addressed when you file for divorce. And the court here has jurisdiction over properties located in the state of Florida, and can equitably distribute those assets here in the state of Florida. They can also deal with issues of rental income coming in on properties that are investment properties and divide up those assets as well. So these are issues that you need to recognize when you file for divorce, and issues that you need to ask the court to resolve. And depending on which side of the argument you're on, you need to leverage those issues to your advantage as much as possible. A few issues I want to talk about today involve a lot of people are affected out there by divorce proceedings that have already happened, awards that have already been made, and they're thinking to themselves, I'm stuck in a situation where I had a divorce recently, and I went into court and I contested the matter and I lost a majority of the issues. In Florida, there are relief and remedies available to you for appeal in the state of Florida, but you need to make an appeal of your case within 30 days of the rendition of a final judgment of dissolution of marriage, or within 30 days of rendition of a final judgment of paternity. That 30 days cannot be moved. So to the extent you're out there listening and you've had a divorce proceeding or a paternity proceeding or any other family law proceeding, and it didn't go your way, there are things that went wrong in your proceedings, whether you're represented by an attorney or not represented by an attorney, you have a right to an appeal, but your appeal runs 30 days following rendition of the order. So keep that in mind if you do have a divorce proceeding or family law matter that went recently and you're considering appealing the case. That's something you need to act on very quickly, or there are no extensions of that time period, regardless of your circumstances, regardless of what's happening in your life, regardless of the fact whether you can afford an attorney or not afford an attorney. That 30 days is set in stone, and if you miss that 30 days, you're forever barred from trying to seek relief from that final judgment of dissolution of marriage or paternity. So your rights are going to be affected severely if you don't act timely. I've personally handled over 60 appeals here in the state of Florida. And the relief that you seek on appeal in any divorce proceeding, you're going to be in a circuit court here in Florida. And the different levels to courts here in Florida, there's a county court that handles typically small claims matters and misdemeanors. There's a circuit court that typically handles any claims in civil court more than $15,000. It handles all family law matters, and it handles all felony matters. And then above that, they have what are called district courts of appeal, and there are different districts throughout the state of Florida. Here in South Florida, the district court of appeal that hears appellate cases is in Palm Beach County. It's a 4th District Court of Appeal, and that oversees Palm Beach County, Broward County, and Miami-Dade County. So if you have an appeal that you want to take from a circuit court action in any area of family law, the appellate court that you're going to be seeking relief in is the 4th District Court of Appeal. If you're going to file an appeal, if you've listened to me on this show, I've given advice on those who proceed pro se, and advise you that proceeding pro se is something that may not be an option for you. It may be your only way of proceeding. If you're going to proceed with an appeal, I strongly advise you to seek advice of an attorney to do so. Appeals are very complicated. The issues that can be heard on appeal are very limited, and trying to do so pro se on your own without the assistance of an attorney is ill-advised. As far as filing an appeal, you don't need to complete the whole appellate process within 30 days. All you need to do within 30 days of the date of rendition of the order you're trying to appeal from, you need to file a piece of paper called a notice of appeal, and it'll cost you $400 to do that. And that will give you another 70 days in which to file your appellate brief with the appellate court up in Palm Beach County. So if you can keep your foot in the door and file the notice of appeal within 30 days of rendition of the order, it'll buy you a couple months to try and get organized to present a case on appeal. Even if you think perhaps you're not going to have the money to hire an attorney to do an appeal, or you're debating whether to take an appeal or not, filing a notice of appeal will buy you some time, a few months, to be able to keep those things under consideration and possibly be able to move forward with those. So if you're listening to the show and you're within 30 days of rendition of your final judgment and you're considering an appeal, give me a call, give an attorney a call to talk about your rights on appeal. I spoke over the past couple months about the importance of having a court reporter at your proceedings to make a record for appeal. Hopefully, if you're considering doing an appeal, you've had a court reporter at your proceedings, because having a transcript of what happened at the final hearing is very, very important to your appellate rights. If you're proceeding to go to a final hearing, or you have a trial coming up, whether you're represented by an attorney or not represented by an attorney, make absolutely certain that you have a court reporter show up to the proceedings with you. You have to pay this court reporter. They're privately retained. It is the best investment you will make to preserve your rights on appeal and otherwise, to have a court reporter at your proceedings. So make sure, if you have an attorney, that you talk to your attorney and ensure that you're going to have a court reporter at your final hearing. What a court reporter does, a court reporter takes down every word that's said at the final hearing. There's a complete record made of your proceedings, and it allows the appellate court then to look at this transcript and know precisely what happened at your court proceeding. And it allows you to make arguments on appeal as to what error or errors the judge may have made during your proceedings. Obviously, without a transcript, the appellate court is not going to be in as good a position to be able to review anything and determine whether a judge committed some error or not, and reverse the case. In fact, it's virtually impossible to do so. So make sure you advise your attorney that you want to have a court reporter at the proceedings. If you don't have an attorney and you're proceeding pro se, there are court reporters all over town. Just go online or look in the phone book and find a court reporter, contact them, tell them when your proceeding is, what judge it's in front of, and you'll need to pay them up front to appear at the hearing for you. But they'll be happy to do it for you, and you'll be well served having a court reporter there at your proceedings with you. On appeal, if you're considering filing an appeal, or if you're going to a final hearing, and you may be filing an appeal in the future, most appeals are handled on a flat fee basis, but you may be in a situation where you've been to trial or you're going to trial, and you may get hit with an alimony award that is significant. You may get hit with child support awards or other awards that are going to affect you for a long period of time. Moving on, the financial consequences of a divorce proceeding or a paternity proceeding could affect you to the tens of thousands, if not hundreds of thousands of dollars to your detriment. So making sure that you haven't been treated unfairly by a trial judge is what the appellate courts do. and you'd be well served hiring an attorney if you feel that you've got the short end of a deal on a divorce proceeding. If nothing else, you should confer with an attorney about your appellate rights to see whether or not you have a basis for appeal. A lot of people go through contested custody cases where the primary time-sharing parent is determined by a trial judge, and as I've said before, in Florida there are no jury trials in family law proceedings. They're all bench trials by judges. So you may have gone through, or you may be going through, as you're listening to this show, you may be going through a family law proceeding. You may have had a few appearances in front of your judge, whether you're pro se or you have an attorney involved, and you may have a gut feeling that the judge has not ruled in your favor on anything thus far, that everything is going in favor of your spouse or the other party, and you get that feeling like when you go to trial on this matter you're really going to lose everything. That happens a lot, and unfortunately there's, as I've said before, family law proceedings are a pretty intimate environment, in that you have a judge who's getting involved in every aspect of your relationship with your spouse and your children, and decisions are going to be made that affect your lives forever. And judges are people. They may have a situation where they see one side of a relationship, or perhaps you went to court, and people get into heated situations in court. These are things that affect their lives, and you may feel that the judge is not treating you fairly. You may feel that the judge rules in favor of the other side more often than not, and that when you go to trial, it's going to be more of the same. This is all the more reason not to give up at that point, but rather to protect yourself. And the way that you protect yourself is you have an attorney, and you have a court reporter there at your hearing with you, and you make sure that the case is presented properly. Because regardless of what feelings you may have about your situation, or how you may feel the judge is looking at your situation, the judge has an obligation to look at your case impartially, to look at all the factors in your case, and to render a decision that's consistent with the laws of the state of Florida and the facts of your case. And if you feel that a judge has not done that, if you feel that the judge has slighted you in some way and made error, you should appeal that case. And to protect yourself and prepare for appeal, you need to have a court reporter, you need to have an attorney at your final hearing. I can't tell you enough how important those two things are. You need to find a way to protect yourself and do all those things. And what will happen at trial, and if you feel this way, you need to trust your gut. If you feel you're going to lose at trial, but it's a matter you have to contest because of the issues involved, it's not something you're willing to settle, you may be walking into a losing battle, and that's fine. It's just the luck of the draw. It's however your case goes. You don't get to choose the judge you get for your case. That's just a random process that the judge is given to you. And you can't change judges as you go along through a case, with very few exceptions and very extraordinary exceptions. So for what it's worth, you're stuck with the judge you get regardless of what happens during your case. And protecting yourself from what you believe is going to happen is very important. Your attorney needs to represent you properly at the hearing. All the evidence you want to be presented at the hearing needs to be presented properly, and record needs to be made of all the arguments you're making on your behalf, so that when you go to the appellate court, everything is laid out there for the appellate court, so that if you believe that you've been slighted in some way, the judge has not followed the law properly, or has made a decision that's inconsistent with the case law in the state of Florida, that you have appellate relief available to you because you made the proper arguments at trial. So all the more important when you feel things are not going your way, to make a proper record in court. It's not the time to give up. It's not the time to say, well, I'm going to lose, so I'm not even going to bother asking for these things. It's all the more reason to ask for those things and make a record, because any issues you do not raise in the trial court, in front of the judge at your trial, are deemed waived if you don't bring them up. So you have to bring them up to present and preserve the record for purposes of appeal. So make sure that you have your attorney prepared to represent you on all the issues you want to present, whether you feel you're going to lose or not, so that you can make a proper record on appeal. The end of the line doesn't come with the rendition of the final judgment. The end of the line comes if you've exhausted your appeals and you have no further relief available to you. Luckily for people out there who are going through a family law matter, the end of the line doesn't come with a rendition of an order from a circuit court judge in one of these counties. If you feel you've been slighted, if you feel a judge has committed some error, you should appeal your case to the 4th DCA here in Florida and try to gain the relief that you think you're entitled to. We're going to take a short break at this point, and we'll be right back with you after these messages. Thanks.
Attorney Sean Shepard has been practicing family law for 18 years, and he is in good standing with the Florida Bar Association. Attorney Shepard is licensed to Florida, New York, and New Jersey. He is a trial attorney with his primary practice in the area of family law litigation. He has handled thousands of cases and hundreds of contested trials before both judge and jury. Attorney Shepard is a former judge, advocate, general court officer from the United States Navy, and therefore possesses a wealth of knowledge regarding military-specific issues to divorce and other family matters. Attorney Shepard not only handles matters from intake through trial, but he also handles all matters of post-trial and appellate work. His unique background has enabled him to develop a keen insight into all aspects of family law litigation, from beginning to end. If you or a family member are about to go through a divorce or have other pending family law problems, contact attorney Sean Shepard today at 954-632-0668. Let attorney Shepard give you sound advice and fight for your rights. Offices in Fort Lauderdale. Call him today to make an appointment. 954-632-0668. You are listening to the South Florida Family Law Show with attorney Sean Shepard, bringing you all the answers to the questions you have about family law. Join the conversation at 888-565-1470. Now, back to our show.
All right, we're back. We're talking before the break about appeals and the necessity of making sure that all your T's are crossed and I's are dotted when going through the process of your final hearing in preparation for what may be an appellate process down the road. And if I can give you any advice, you need to trust your gut on how things are going. If you've been in front of a judge a few times on your case, and your gut tells you that the judge is leaning one way or the other on your case, don't ignore that. That's things you need to take into consideration when you're determining whether to contest certain issues or not. If it's something you believe in and you want to contest an issue, and it's something you think you can't live without, by all means present a case in your favor, put on the evidence you want to put on, be respectful to the court, be respectful to the other party, make a record of the situation. If you lose, you do have an appellate relief available to you to contest the matter further on appeal. Now, in Florida, one of the big issues in any family law matter is the court's discretion to award attorney's fees and costs. And this is sometimes one of the biggest bargaining chips anybody has in a case like this. Because regardless of who wins the case, who loses the case, an award of attorney's fees and costs is driven solely by one party's financial need for attorney's fees and the other party's ability to pay attorney's fees. Now, in contempt situations, there is a factor involved in contempt situations where award of attorney's fees can go to the prevailing party, regardless of the need for attorney's fees and costs. But one of the things you need to take into consideration when determining whether to appeal a case or not is the impact of an award of attorney's fees and costs. So in evaluating that, that's something you should speak to your attorney about, because if you, for instance, are the breadwinner, and you went to trial and you lost and you got hit with an attorney's fees and costs award that you have to pay to the other side, and you otherwise lost on a lot of issues and you want to appeal the case, right out of the gate, the other side can ask for an award of appellate attorney's fees and costs. And if you're in a situation where you have the ability to pay that, typically those awards will be made. The award of attorney's fees and costs have been pared down in recent years with new cases that have come out of the DCAs. On the basis of appeals, lots of mistakes are made every day in divorce court and in paternity court. So if you're there thinking that there's no way that you're going to win on appeal, that it's a lost cause, you're wasting your money, there are books that line walls of every law office in the state of Florida filled with cases where there have been mistakes made by judges and juries that are a basis for the importance of appellate work and the effectiveness of appellate work. So it is not a lost cause, and it's something you should, at the very least, if you've lost at trial and are considering your options, it's something you should confer with an appellate counsel about. I do that work, and I offer free consultations to anybody considering filing an appeal to review your rights and see what happened at your trial, to see if there's even a basis for you to appeal the case. And there are others out there who offer free consultations as well for anybody considering going to file an appeal. So despite the fact that you've just gone through a process and lost at the trial level, you should not feel down by that and just give up hope on every option of relief that may be available to you. But going through an appeal, like I said, is typically it's a time-consuming process. Right now, if you were to file an appeal, in my experience, and I've handled over 60 appeals myself, you're typically looking from start to finish from anywhere from 10, 11, 12 months all the way up to 18 months as far as a turnaround time on appeals. And that depends primarily upon how quickly the briefs are filed and the caseload of the District Court of Appeal that's handling your case. But it's not a quick process. It's not something that you're going to file a notice of appeal today, file a brief next week, and you're going to get an answer in 2 months. It just doesn't work that way. The appellate process takes quite a long period of time, but it can be very, very rewarding. But keep in mind when you do file an appeal, particularly if you're on the side of the equation where you make the majority of the money in the relationship, that you could get a request from the other side that appellate attorney's fees and costs be paid. Now, there have been significant changes in the law recently that very basically stand for the proposition that if you go through a divorce proceeding and everything is divided equally, you each get your share of the marital assets and debts, and are both made equal from an income and expense standpoint and also from an asset and debt standpoint, so that both people are on a level playing field, so to speak, that an award of attorney's fees and costs is not appropriate. And it makes sense. If both parties are in the same financial position from income, expense, asset, and debt standpoint, neither should have to pay the other's attorney's fees and costs. Now, of course, that changes to the extent that there is an unequal distribution of assets and debts, or if one party's making significantly more than the other, and the other is not in a position to be able to pay their own attorney's fees and costs. In Florida, historically, whenever there is not a level playing field financially, or one party is not able to pay their attorney's fees and costs and the other is able to contribute to those, very generally speaking, both trial courts and appellate courts typically want to level the playing field and allow both parties the same financial ability to retain counsel to represent them both at the trial level and at the appellate level. So keep that in mind when you file for appeal. If you've gone to court at trial and you were awarded attorney's fees and costs but lost your alimony claim or lost on some other significant issue and you're considering appealing a case and you don't have the money to appeal, keep in mind that you can ask for an award of appellate attorney's fees and costs to allow you to appeal. And if you're able to demonstrate to the court that you have a financial need for those fees and the other side has the ability to pay, that you may be entitled to that relief. So there are a couple different options available to you, and it's certainly something you should confer with an attorney about very quickly, because there's only 30 days from the rendition of the order to file a notice of appeal. So keep all that in mind. There are other forms of relief other than appeal that you should be aware of, and you may be in different situations listening to the show. You may have gone to a hearing before a general magistrate for temporary relief. You may have gone to a hearing before a general magistrate on something else in your divorce action, and you're trying to find out if there's a way that you can seek relief from what is called a report and recommendations by the general magistrate. Typically what will happen is that if you have a motion for temporary relief, or if you have a motion for contempt that's post-dissolution, or any type of motion in that regard, those are typically referred to a general magistrate. General magistrate is not a judge, and those of you involved in the process who are unfamiliar with what a general magistrate is, general magistrate is typically an attorney who is not a judge yet, who gets referrals from the judge to hear less significant matters that the court refers to them to be heard. What happens next is you in some circumstances have a right to object to the general magistrate hearing your case. In some circumstances you don't. If you don't want a general magistrate hearing your case, consult with your attorney about it and see if there's a way that you can object to the general magistrate hearing your case. If you want to be, for instance, in front of the judge as opposed to a general magistrate, there are some circumstances under which you can object to that, but you have a very short time frame to do that. It's only 10 days from the date of referral to a general magistrate. Once a general magistrate hears your case, whether it's for temporary needs, if you're trying to get temporary alimony, temporary attorney's fees, temporary time sharing with your children, and you go before a general magistrate, or if you have a motion for contempt and it goes before a general magistrate, once you have a hearing before a general magistrate, they issue what's called a report and recommendations. It's not an order because they're not a judge. They don't have the ability to enter an order. And what that is a report and recommendations by the general magistrate to the judge, and it says what they suggest the order should say. It includes findings of fact based upon the evidence presented at the hearing, and within 10 days of issuance of that report and recommendations, you have an ability to file what are called a notice of exceptions to that. And there are very limited circumstances under which you can file a notice of exceptions to what a general magistrate's report and recommendation says. But in an abundance of caution, if you have any problems with what a general magistrate's report and recommendations say, if you disagree with it, what I would suggest you do is file a notice of exceptions to the report and recommendations, or have your attorney do so. And what that does is it gives you the ability, if the general magistrate has not followed the law properly, or if for some other reason there's a deficiency in the report and recommendations, and you file an objection to that, and it's in the form of a notice of exceptions is the formal term for it, the court would then look at that, the judge would look at that and determine whether or not there's a legitimate basis for a modification to the report and recommendations by the general magistrate. So it's not an appeal, it's simply a notice of exceptions to the judge to try and get relief from what otherwise is an adverse report and recommendations by a general magistrate. So that's another form of relief you may be entitled to seek. Be aware, though, that the time frames for filing that are very short. It's only 10 days. It's not like a regular appellate deadline, which gives you 30 days to do that. So keep that in mind as well. What happens is unlike your divorce proceedings where you go to a final hearing, any hearings before a general magistrate have audio recordings. So you don't need to bring a court reporter with you to a general magistrate hearing. It's automatically recorded. If you do file a notice of exceptions to what the general magistrate does, though, the court's going to require you to present a transcript of what happened in front of the general magistrate so that the judge could then read what happened and determine whether your notice of exceptions has any merit or not. So keep that in mind. It is an additional expense that you have to undertake to both get the CD of the audio recording of the proceedings and then bring that to a court reporter and have it transcribed, but it's necessary for you to do that in order to proceed with filing that notice of exceptions. One other thing you need to consider is as far as an ability to seek some relief from things that have gone wrong. And we've talked about a few different things today, both appeals, notice of exceptions. Even if you've gone through a divorce proceeding or a paternity proceeding, and even if you got to the point where you missed your deadline to file an appeal, which expires 30 days after rendition of the order, it's not necessarily the end of the line for you, although most of your rights to contest that final judgment are waived if you don't appeal within 30 days. There are limited forms of relief that you can obtain from a court, even months or years after your divorce decree has been entered or your paternity final judgment has been entered. And those come in the form of modifications. And if you've listened to the show, we've talked briefly in the past about seeking modifications. Modifications are relief that are awarded to people when there's been a substantial change in circumstances. And modifications are obtained by you filing what's called a supplemental petition. A supplemental petition is a filing that you need to file with the court. You need to obtain a summons from the court, and it's similar to restarting a whole new process, but it's under the same case number as your divorce proceeding. So by way of example, to illustrate what I'm talking about, if you went through a divorce proceeding and an alimony award was entered in favor of your former spouse, ordering you to pay $2,000 a month in alimony permanently, what you can do to seek relief from that order, if there has been a substantial change in circumstances, file a supplemental petition to modify alimony. And what you need to allege in that supplemental petition is that, there's been an order entered, a final judgment ordering me to pay $2,000 a month in alimony to my former spouse, that order was entered on such and such date, that subsequent to that date there's been a substantial change in circumstances to it, and then you list out all the things that have changed since entry of the final judgment of dissolution of marriage. And here's where the difference is to whether or not you're entitled to relief with a supplemental petition. If there has not been any substantial change in circumstance since entry of the final judgment and you did not appeal the case, you're not going to be granted any modification. So that's where your appellate rights are important if you want to seek relief from a final judgment. Because the only way that you can seek relief from a final judgment after an appellate period has run and you haven't filed an appeal is through a modification. So hopefully, in the situation I've made up here where you're paying alimony of $2,000 a month, there has been some substantial change in circumstance that warrants a change in your alimony obligation. And in this example, a list of things that may entitle you to seek relief in the form of a modification from alimony may be that you've had a reduction in your income, that the other side has had an increase in their income, that the other side has remarried, for instance, because that would terminate any alimony obligation. that the other side has expenses that have decreased substantially since you've divorced from them. Perhaps the person you're paying $2,000 a month in alimony to was living in a house where the costs of living in the house were $4,000 a month, and now they've moved into a rental that's $1,250 a month. And these are things that you need to monitor from a distance in order to make sure that you're not overpaying what you should pay in the form of support. Perhaps the person you're paying support to at the time you got divorced was paying a lot of credit cards or paying a bankruptcy trustee payment or paying student loans or other debts that they had. And that payment of debt factored into the $2,000 a month that you were paying them for support. And maybe you're 4, 5, 6 years down the road and all those debts are gone. That's a basis for seeking a reduction in alimony. There's also a basis for seeking a reduction or an elimination of alimony in Florida based upon cohabitation. And I get a lot of questions about cohabitation and what cohabitation is, very generally speaking. Cohabitation is a basis to terminate or reduce spousal support and alimony based upon an allegation of a substantial change in circumstances, to wit, my former spouse is now living with another person in a romantic relationship and they're financially dependent upon one another. And based upon that, you shouldn't have to continue to support the other party through the payment of alimony. And recipients of alimony have become smarter in these days, and that they're not remarrying because of the alimony they're receiving. And obviously, remarriage automatically terminates alimony from an entitlement standpoint. You still have to file a supplemental petition to stop it from continuing. But if you file a supplemental petition based upon remarriage, the court's going to grant that relief to you and stop the alimony obligation from your end. But a spouse who's receiving $2,000, or former spouse, who's receiving $2,000 a month in alimony is not going to see the need to remarry. In fact, would probably live with somebody in order to avoid having to lose their alimony payment each month. And again, observing from a distance, if you become aware of the fact that your former spouse is living with somebody else and that they are financially dependent upon the other party, and there's a whole bunch of factors that come into play at hearings of that kind, you should certainly file a supplemental petition to seek a modification. Now, a lot of people tactically come and they see an attorney, and it may be, they found out 2 weeks ago that their former spouse moved in with another man, or vice versa, and that they want to file a supplemental petition to modify because they believe something's happening there. Despite the fact that you may want to feel like you want to file that immediately, you may be better served waiting to file that so that that relationship can develop to a point where you're able to prove that they're financially dependent upon one another. Hypothetically, if you had a situation where you're paying $2,000 a month in alimony to your former spouse, and you find out 2 weeks ago that they moved in with somebody else, or they allowed somebody to move in with them, and you immediately go out and you file a supplemental petition and you have them served with it, what you may find happening after you serve that petition is that the other party moves out immediately, and all of a sudden what appeared to be a promising situation where you may be able to avoid paying alimony turns into something that completely deflates because of your wanting to act too quickly. You may be best served in those situations by allowing, like I said, the relationship to develop, to not give any indication to the other party that you're going to seek a reduction or elimination of alimony, and to hopefully allow that situation to develop to a point where you're able to actually prove to a court that the other party has, for instance, changed their address so that they both have the same address, that they actually start sharing bank accounts and sharing expenses, that they both contribute to the expenses of that one household, and allowing that relationship to season, and allowing that information to solidify may help you in actually proving your case. So it may be worthwhile to wait 2, 3, 4, 5, 6 months so that when you go into court and you present the case to a judge, that you have several months where the parties have resided together and that they have a financially dependent relationship on one another. And what you're trying to do is to go into court and say, Judge, even though my former spouse is not remarried, he is living with somebody else or she's living with somebody else. They're in a financially dependent relationship. They both have driver's license with the same address. They share a bank account. They each contribute to the mortgage payment. They're both employed, that type of thing, because that's ideal for your situation where you can try to seek relief for a modification of your alimony. So if you're in that type of situation where you feel like you might be entitled to a modification, you should definitely confer with an attorney to see if you have enough to go on to file a supplemental petition. We're at the end of the hour here. My name is Sean Shepard. I've been an attorney for 18 years, handle family law. We've talked about a lot of issues today. I can help you with your family law issue. If you need help with any issue, or you know somebody who needs help with any issue regarding family law, give me a call. My office number is 954-632-0668. I offer free consultations on all new matters, including appeals and including trial work. Please call me if you have any questions regarding family law, and I'd be happy to meet with you and discuss any fee arrangements we have regarding your matter. I appreciate your time in this hour. I wish everybody a safe and happy holiday. Happy 4th of July. And I'll talk to you next week. Thank you.
Thanks for tuning in today to the South Florida Family Law Show with attorney Sean Shepard, with offices in Fort Lauderdale. If you would like to set up an appointment with attorney Sean Shepard, call his offices at 954-632-0668. And tune in again next week for another South Florida Family Law Show with attorney Sean Shepard. And let Sean answer your family law questions. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.